Madam Trendafilova, thank you for talking to KoSSev. Let's start the interview with a, let's say, general overview of the processes that are being conducted in the specialist chambers. How many processes are now in progress and what stage they are in?
Yes, actually, when I respond to a question that you kindly addressed to me now, I always clarify that the specialist chambers have been seized only in late autumn of 2020. So what we have achieved so far is just related to this 3 years period, when we have one final case against the administration of justice, Mr. Thaci, Mr. Haradinaj. We have also the case, the first war crime case. On Monday, the appeals panel issued a scheduling order that they are going to render in public in the courtroom, the final decision against Mr. Mustafa for war crimes. Then we have the other two cases against Mr. Shala, again a war crime case, and against Mr. Thaci, Veseli, Krasniqi and Selimi at the trial stage of the proceedings. They're advancing with a quite good pace. Mr. Shala case will be finished with a sentence rendered by the trial panel next year, latest by the middle of the year. And we have also the first reparation order for victims that have been granted the participatory status in the proceedings against Mr. Mustafa. And there are recently some arrests that were conducted here in Kosovo against Mr. Zinusi, Bakhtiari, and there are charges that are pressed against them. So after the initial appearance, the pretrial proceedings are ongoing before the pretrial judge. And we have also Mr. Kilai, who has been arrested based the arrest was based on an arrest warrant of the Specialist Prosecutor's Office and the transfer judicial order that was issued by the single judge. So, well, if there would be charges pressed, then the pretrial judge is going to finally decide whether to treat Mr. Kilai as an accused person or not. Yes. So that is where we stand so far.
Yes. Let's talk about the trial of Hashim Thaci and the others. It's well underway. We have witnesses that are being questioned. We have witnesses who make direct accusations against accused or people that were subordinate to them for war crimes. When can we expect the conclusion of this trial? And I know that you're president of the court, but can you give us what outcome do you foresee when it comes to this?
Well, actually, I'm not a judge sitting on this case, so I know what everyone else knows. For example, when in my office I have a screen where, when I can afford it, because I have many other duties as well, I follow the proceedings. But when the court goes into private sessions, they're private for me as well. So I do not have much knowledge about this beyond the knowledge of everyone who is following this case. But what I can say, of course, this is a very voluminous case because every one of the 4 accused has been charged with 4 counts of war crimes and 6 counts of crimes against humanity. It is an extremely voluminous case, and it will take longer than the case against Mr. Mustafa and Mr. Shala and Mr. Thaci and Haradinaj, certainly because of the different dimensions of this case. Of course, witnesses have to appear and to fulfill their civic duty, just to provide their recollections of the facts that are related to the charges. Of course, they have to be sworn in, that they will only speak the truth and nothing but the truth. Some witnesses, of course, we have witnessed following the proceedings, that they expressed the concerns that you were referring to, that they don't want to testify. Last week, for example, a witness said, but this is not the only one, who made it very clear, I would rather go to jail, but I will not testify. But these are isolated instances where we have witnesses really being very, very much concerned about testifying. The rest of the witnesses appear. We have a very, very strong witness protection program. We have a very strong specific unit dealing with witnesses, with psychological support. And there were some witnesses having appeared before the trial panel 1 or trial panel 2. They said, going back to Kosovo or elsewhere where they reside, that they have never been treated with so much care by the staff of the registry that is specifically focusing on protection of witnesses and providing all support before, during, and after their witness testimony. When the case will be finished, it's very difficult to say, because the prosecutor has provided for quite a number of witnesses, over 300, of course, what is very much impressive, and what actually we have also reflected in the rules of procedure and evidence. The judges, when we adopted the rules of procedure and evidence, we provided for responsibilities of the judges to streamline the proceedings in order to manage the proceedings properly by setting some specific dates up until which they have to handle with different issues on their desk. Also, pursuant to our legal framework, judges have asked the parties during the first hearing that they reduce to the extent possible witnesses that are repetitive, that do not bring anything new. What judges are doing is really very much impressive towards expediting the proceedings, but at the end of the day there should be a balance with the fair trial conduct of the proceedings, which is provided, as we know, in a number of international normative documents like Article 6, Paragraph 1 of the European Convention, the International Covenant on Civil and Political Rights, and extensively in the law, in the Constitution of Kosovo, and also in the rules of procedure and evidence. Let us believe that this is not going to take too long. Also, the defense, we don't know how big the cases of the defense are going to be, and there we have 4 defense teams. So judges are taking their role very seriously towards expediting, but at the same time with full respect for the rights of those who are brought to account.
Regarding the witnesses, the Special Prosecution Office asked recently court to restrict visits and communication for Hashim Thaci, Kadri Veseli and Reto Psirimi, because, as they stated, they revealed the identity of individuals under witness protection program, and also asked people to give up their testimony. They claimed that, Special Prosecution claimed that they had, is it okay to say, eavesdropping warranty?
Yes,
and the court approved it.
Wiretapping or eavesdropping, that is the terminology that is used, yes.
So when did the Special Prosecution file this warranty, and what position is of the Special Chambers regarding these accusations? Is this true?
Well, actually, I again can provide my response to you as an outsider to these proceedings. And I'm not pretending to be, I'm actually an outsider. I follow with interest all developments, not only in this case, in all cases. Of course, I know what is a public filing. Beyond this, it's not possible, and it is inappropriate. I will never breach the confidentiality and independence of judges, and no one of my colleagues will equally do the same. So here, of course, we can think of the urgent prosecutors' request for measures like segregation of the 3 out of the 4. Mr. Krasniqi is not part of this prosecutor's request addressed to trial panel 2. Also for limiting, suspending the communication or the visits with the 3 of them. And on the 17th of November, the trial panel took a decision which is interim decision, meaning that they will take their final decision on the prosecutor's motion only after they have received a detailed justification provided by the Specialist Prosecutor's Office, and also the views of the registrar on this. And of course they will hear the parties. Only then the judges are going to take the final decision. Indeed, they took these interim measures in order to prevent that information which is confidential is not communicated to persons that are not entitled to receive this information. And of course, the main, if you read the judgment, it's a short judgment, but very, very clear, making reference to Article 8 of the European Convention on Human Rights and Fundamental Freedoms, that the private life of anyone under the protection of the European Convention, that there are no breaches if such measures are to be taken. Of course, it will be decided on the basis of the facts and the views of everyone who has been invited to provide views. And here the main concern is to protect the life and well-being of victims and witnesses, to protect the integrity of the proceedings, because without witnesses who might decide not to testify, regardless of what the law provides, that they could be fined, that they could be sent to prison, they could be in prison for up to 1 month, and so on, still people have to feel safe and secure when they appear before us. And as delivering the judgment in Mr. Gutsati and Mr. Haradinaj case, the presiding judge, who is the presiding judge in this case, Judge Charles Smith, said that witnesses are central in any system, be it domestic, be it before an international court, and all measures have to be taken in order for them to be able to come up and fulfill their civic duty. And this is actually, their protection is the foundation in any democratic system that respects and promotes the rule of law. So let us see what will be the decision. It was impressive that the judges just provided a very, very short period within which, 1 or 2 days, within which everyone who was invited to provide their views have to fulfill their obligations vis-a-vis the chamber.
Yes. Regarding to this, by the order of special prosecution, we had a couple of, like you stated earlier, searches and arrests at Kosovo. We had phones and other items taken away from the people that were close to Thaci, his ex-advisors. Is this connected in any way with the eavesdropping of the Thaci communication and others? So is this connected with that? Did they do the searches because of the witness, protected witness information were being leaked or something like that?
Well, actually, I don't know. You know that even the design of our relocated institution, as we are referred to in the whole state agreement in the singular, we are 2 different institutions. And I'm not saying this just to avoid responding to your question, but I have to say that we even, the prosecutor's office is in a different building. We are not even under one and the same roof. So I don't know what the intentions of the prosecutor are. What actually has driven these undertakings by the Office of the Prosecutor, searches, seizures, not only of telephones, maybe of something else that pursuant to the search has been found. I really cannot respond to this question. It will be just some inventions, and that is not professional. I can't do this. It is actually de facto, not only de lege, but de facto we really are different, and there is no any mixture between us. Only, for example, if there would be some New Year celebration, but we invite chambers, organize it, the registrar mainly, invites the chambers, invites the specialist prosecutor staff, but also the defense. And our defense lawyers, our colleagues speak out during such events. So that is how it is. Apart from that, no any relations, any discussions, no.
But one technical question. Before the special prosecution starts with any kind of search, do they inform you? Do you have information about that search?
Well, actually, yes, I understand. I'm sorry, I interrupted you because this is the response to this question, of course, is in our rules of procedure and evidence. We provided for special investigative measures apart from and search and seizures as well. And search and seizures could be conducted. There could be two ways to go ahead with searches and seizures. One of them when the prosecutor would approach a single judge during the investigation, there should be a judicial authorization. And if the judge decides that there is a good justification for a search and seizure, then there is a decision taken by the judge. However, we have also provided, which is also a universal approach, it's nothing unique. This is in the Kosovo domestic system, it is in any domestic system that we could discuss at the international level as well, that in some cases where the prosecutor has to proceed without waiting this authorization because the result wouldn't be achieved, then, as was the case with regard to Mr. Kilai, there was just the search and seizure based on the order of the prosecutor, and then within 48 hours there should have been authorization by the single judge, because if such approval authorization wouldn't follow, then the result of this search and seizure cannot be used. So
approval comes later, sorry. Approval comes later.
Up
after.
until 48 hours, but that was the only case when it happened this way.
We are aware that specialist chambers have emphasized the importance of witness protection.
But on the other side, we have a special prosecution claiming that intimidation of witnesses reigns in Kosovo. Is this statement valid or not?
Well, I know about this statement because it was made public.
Yeah.
Actually, the uncertainty about the safety and security of witnesses and also victims has motivated the High Representative back then, Baroness Catherine Ashton, and the then President of Kosovo, Mr. Hague, to agree on this international agreement for the establishment of the specialist chambers and specialist prosecutors' offices, so they be relocated to another country in order to protect witnesses and victims based on the experience with other courts and tribunals, be it domestic, be it at the international level. And here I can refer to cases before domestic courts of Kosovo, purely domestic, UNMIC, ICTY, and this was thereafter reflected in the constitutional amendment, Article 162. Thereafter, of course, resonated, reflected again in the law, specialist chambers and specialist prosecutor's office. And that is really what, from time to time, in some public statements, the specialist prosecutor's office is conveying to the public that there is this intimidation of witnesses. And we see that there's a number of cases. Out of 6 cases, 3 are related to offenses against the administration of justice, mainly intimidation of witnesses.
Exactly, and that's why I want to remind you on what you stated for Kosovo last year in an interview. You said that the witnesses who came to testify before the special chambers must feel safe and secure because of the numerous measures. But after these allegations by the special court, after the testimony of witnesses who stated that they are afraid in some way to testify, would you say that that is really how they feel? Do they really feel safe?
First of all, I specifically underlined since my first visit, it was again in November in 2017, that no judgment should be appreciated when this judgment has been delivered at the expenses of the life, well-being of anyone who cooperated with any court in any domestic system. So really the protection of people who are ready to come and provide their memories about events that fall under the charges expressed by the prosecutor and confirmed by the pretrial judge. People have to feel safe and secure. And what you're referring to indeed happened, and happened a week ago. What I was following, of course, on the screen next to me, about 2 witnesses, but the rest of the witnesses are appearing quite strongly. Of course, there are a lot of protective measures. There is a psychologist working with them before they go into the courtroom. If someone feels unsafe, psychologically under some pressure, disturbed, and so on, the hearing could be interrupted. That the psychologist thereafter, of course, works with them. But people, the general approach by the witnesses is that they would like to come and testify, telling their story.
Yes.
Of course, thereafter the judges are going to decide based on their analysis of the evidence and comparing every single piece of evidence to the rest of the evidence put in a system. They will decide on the credibility, reliability, relevance, of course, the weight to be given. So it will come at the end during the deliberations.
When it comes to victims, people with victim status, one technical question: do you maybe have information how many people have applied for the victims program, and what is their position and status? And what exactly does the court provide them? Can you make difference between victims and people who testify, who are witnesses? Yes. And do you have information about ethnicity of victims? Yes.
On that I have, because this is in the public decision. So first, the response to your question is related to the numbers of those who applied. It is something very interesting just to follow. Maybe I might make a mistake about the exact number, but I think that over 350 have applied for the participatory status of victims participating in the proceedings. And I have to say that this decision is not just granted. Whoever applies, and then the request, the application is granted, and the applicant becomes a victim participant. Almost half of those who have applied have not been granted this status. 8 victims in the Mustafa case, all of them of Albanian ethnicity, and the same in the case of Mr. Shala. Such a coincidence that again 8 victims have been granted this participatory status. In the case against Mr. Thaci et al., Krasniqi, Selimi, and Veseli, 141 victims have been granted till now the status of participants. Of course, the victims are not parties, they're participants, and they participate in the proceedings via their legal representative, by victims' representative. And they have the right of notification, acknowledgement, and reparations. And we have the first reparation order that was issued in April of this year. Let us see. Of course, it is very important to see what the appeals judgment, which is the final judgment, will be. Although I have to be very specific on this, Mr. Mustafa has not appealed the reparation order. So, but anyway, if, for example, the appeals panel will decide that he is innocent, then the reparation order, let us see what's going to happen. Obviously, victims will not be compensated, but this is just a hypothetical scenario. Yes. But in this case, there are also, because the number of victims is quite different, there are Albanians, there are Serbs, as far as I know, there are Romas. So any ethnicity. What matters is that those who apply satisfy the requirements to be granted, and they have to be direct victims of the crimes allegedly committed, and such a decision is taken very, very seriously with regard to every single applicant.
Well, let's go back before the establishment of specialist chambers. Movement Vetevendosje Samopredeljenje, they've been one of the voices who are really against the establishment of these specialist chambers before establishments, in the moment when they were opposition. What would you say now when they are in power? Is there a pressure when it comes to work of specialist chambers in any way?
So first, let me clarify that I have never participated in the establishment of the Kosovo Specialist Chambers. This was a decision that was taken, not easy. The whole very, very difficult and taking a lot of time way started with the resolution of the Security Council 1244 of the United Nations Security Council. Thereafter, it was taken over mainly by the European Union. And of course, very importantly, following the exchange of letters, the Parliament of Kosovo approved this international agreement, adopted, of course, following the decision of the Constitutional Court in April of 2015, adopted thereafter enacted the Article 162, this amendment to the Constitution, our law, and then the court was established. So now, indeed, this party has an important role to play in the political life of Kosovo, of the Republic of Kosovo. And I have to say, and I will always firmly confirm, no one, be it from Kosovo, be it from wherever else, has tried to put any pressure on us. And trust me, regardless, there could be speculations, there could be stories, never, ever. And this is to the credit of all those who might have been considered to have an interest to put pressure and so on. First of all, that is to their credit. Second, I believe that our court has its reputation of everyone who works in this institution. We have been selected following a very, very robust, serious, strong selection process. Everyone in specialist chambers, be it judges, be it staff members, has really proven to be a highest professional. And till now, I have never heard of any one of my colleagues to have been subject to any pressure. And as president, I'm telling you, this never happens.
But once again, just like the last time you were here, we have announcements of protests. We have a part of opposition, right now opposition, and KLA ex-members, they're protesting against your arrival. We had photos on social media. They want you to be persona non grata at Kosovo.
Yeah.
How do you comment?
Well, let me say, first of all, it's not nice to be called persona non grata, but I take it as maybe the view of people who have to come to discuss, to ask their questions with open mind. And I'm here to respond to any questions. Of course, everyone has the right to express his or her opinion, reservations, doubts, concerns. And that's why I said yesterday, even if this late flight will be cancelled, we're going to overnight there at the airport, but I will come just because I want to meet everyone who would like to address any question, including questions of doubts, disbelief in what we do, just because I am in a position to give an objective, not fake, not misleading responses to all these questions. And I'm looking forward to this meeting in the afternoon with the civil society. It is the most important purpose of my visit, because we relocated, as it was decided by in the international agreement, thereafter, of course, approved by the National Assembly of Kosovo. We just do our job, mainly for the protection of witnesses and victims who would like to take part in our cases. And then, of course, I find it my duty to come at least once a year, to come to inform everyone who is interested about our performance, about our operation, and to respond to any questions. I'm not worried about any question to be addressed to me. So I would invite anyone who doesn't trust my colleagues, our institution, the Kosovo Specialist Chambers, and myself personally, just to come. There is nothing to hide. There are no tricky games. There are no politics, not at all. Politics is not for us, not just because it is normal to say that judges shouldn't get involved in politics. When I say this, I make this point with all my respect to politicians, because politicians have to be educated in the field of political science. They have their routine, everyday engagement with politics. They know a lot in their field. We are ignorant, and we don't want to become educated just because that is not our job. And we, of course, what happens here is very important for us. However, we do not engage in a political context.
Madam Trendafilova, once again, thank you for talking to us.
Yes, my pleasure again. So thank you very much for inviting me.